Hi, I'm Emily Hancock, Chief Privacy Officer at Cloudflare, and I'm happy to be back here at Bitkom. When Cloudflare was founded 14 years ago, it was on a value proposition to help build a better internet by making it more secure, more reliable, and more performant. Pretty quickly, we also realized that a better internet is a more private internet, and we've been playing an active role in building more privacy into the internet ever since. Not only do our core services provide security that further enhances data privacy by preventing breaches of stored data, but we also dedicate resources to building privacy enhancing technologies that help people use the internet without having to give up personal information to do so. We invest a great deal in privacy enhancing technologies and products because we believe that privacy is critical not only to our own operations, but also to the future of the internet. And now, with a global network spanning more than 330 cities in over 120 countries, Cloudflare sits in front of roughly 20% of the internet. We help protect websites and corporate networks from cyber attacks. Today, I want to go a bit beyond privacy and talk to you about something we've been hearing more and more about over the last few years: data sovereignty. This concept of sovereignty, which is essentially the right of an individual or group or nation to control data, is often associated with data localization, which is the idea data should stay in the country or region where it originated. We've been observing a growing trend of data localization worldwide. In the EU, it's largely driven by two factors. First, there's what we believe is an overly restrictive interpretation of the GDPR shared by many data protection regulators. And then second, we see explicit data sovereignty requirements for reasons of national security based on a pretty narrow understanding of sovereignty. But as I'll explain, the reality is data localization can have a negative impact on cybersecurity. And without really good data security, we can't ensure data privacy. And if we can't offer individuals assurances around the privacy and security of the data, then there can't be true digital sovereignty, which is the ability of individuals to securely use the digital services of their choice and control their data as they move around the global internet. So today, I want to talk about how we should be striving for an internet where location doesn't matter, where we ensure privacy and security of data no matter where it's processed. Before we dive into that, I want to take a moment to remind ourselves of privacy first principles. The Fair Information Practice Principles, or FIPS, are the foundational guidelines for protecting personal information. The FIPS are widely adopted, and they form the basis of most data protection legislation around the world. The FIPS include, first, the principle of transparency. Tell people what personal data you're collecting and why. Second, the principle of choice. Give individuals the right to choose how their information will be used. Third is the idea that individuals should be able to review and correct their personal information. And fourth is ensuring the quality and integrity of the personal information that are protected. Fifth, we have the principle of accountability, holding organizations accountable for complying with the FIPS. Six is the principle of consent. And then last, but definitely not least, the principle that entities collecting personal information but must ensure that that data is kept secure. Now, while the principles aimed at giving individuals notice, choice, and the ability to control what happens to their personal information are pillars of any approach to data protection, it's that last principle, security, that has become more and more important. We know that many individuals don't read the privacy notices we painstakingly craft for them. I know, it's shocking. We also know that most people have consent fatigue. Think about how many cookie banners we all just accept so we can get to the content we really want. But securing data is one thing that individuals can't really take control of. Banks are online, health records are online, and we shop online. All of these life tasks take place online, and we have little choice but to hope that our personal medical records, our credit card statements, our shopping habits won't be hacked and published on the internet for everyone to see. Now, I don't love that advertisers know my web browsing habits and use that to show me targeted ads. But you know what I hate even more? When my health insurer fails to implement robust security measures and my medical records are exposed, or when I become vulnerable to identity theft because a data broker failed to properly secure my social security number. And those are just two data breaches that I was notified about in the past 9 months. So to my mind, when I think about the FIPS, I can't help but think that the principle of security has to be given priority. And that leads me to my next point. Let's talk about how an overly restrictive interpretation of the GDPR can, somewhat counterintuitively, undermine cybersecurity, resulting in less effective data protection. Now, on balance, the GDPR has definitely moved the needle in the right direction for giving people more control over their personal data and in protecting their privacy. And as drafted, the GDPR does not require data localization. Instead, it allows data to be transferred outside the EU if certain measures are met, and it allows data controllers to make a risk-based determination on whether data will be adequately protected when it's processed outside the EU. But in the last few years, data localization pressures arose largely due to the Schrems II case. In the wake of that court decision, many data regulators began to assert that no data could leave the physical boundaries of the EU and be protected, certainly not if a US company was involved. The EU-US data privacy framework has provided cover for EU companies that want to use US service providers, but the sentiment remains. Location has become a proxy for privacy in the minds of many EU data protection regulators, and we think this is a wrong equivalence. Going a step further, the way GDPR has been applied to cross-border data flows may in fact actually jeopardize the protection of personal data, as I'll explain. Our experience and recent research have shown that GDPR-induced data localization threatens an organization's ability to achieve integrated management of cybersecurity risk, and it limits an entity's ability to employ state-of-the-art cybersecurity measures that rely on cross-border data transfers to make them as effective as possible. This directly clashes with the obligation Article 32 of GDPR places on data controllers and processors to, quote, develop appropriate technical and organizational measures to ensure a level of security appropriate to the risk, taking into account the state of the art. In addition, data localization undermines information sharing within industry and with government agencies for cybersecurity purposes, which is generally recognized as vital to effective cybersecurity. Now, the idea of data localization or data sovereignty has popped up in a number of other policy initiatives as well. We're seeing an increasing interest in the EU in matters of digital sovereignty, for both reasons of national security and global competitiveness. It's been an important goal of the EU and its member states for a while now to reduce technological dependencies on a few third country providers, and geopolitical developments have further exacerbated this trend. The much-cited Draghi report on the future of European competitiveness also emphasizes the need for technological sovereignty due to rising geopolitical risks. It suggests that a country, or in the case of the EU, a group of countries, can best defend its national security interests by relying on providers within that country or jurisdiction's borders. And we'll soon have a new European commissioner in charge of tech sovereignty. These are all a part of a trend we're seeing around the EU's efforts to become more competitive in the long run and encouraging technological sovereignty to avoid dependence on other countries. The quest for digital or tech sovereignty is, of course, legitimate, and it's understandable from a European perspective. But the desire to gain more control over what happens with European data is getting mixed up with privacy and security considerations in ways that can actually be worse for data privacy and security. So let's take the example of what happened when Russia invaded Ukraine. Ukrainian law required national security data to be stored within the country, presumably because in-country storage was perceived as being better for maintaining control and security over the data. But when Russia invaded, the Ukrainian government had to scramble to change its law and move its most sensitive national security to cloud storage solutions hosted outside of its territory to protect it from invading Russian forces. Meanwhile, in a paper published last year, the Conference of Independent Federal and State Data Protection Supervisory Authorities in Germany went beyond their task description by setting out criteria for so-called sovereign clouds. They argued that companies that market their cloud offerings as sovereign should fulfill certain conditions. In particular, that data be processed exclusively in the EEA by providers based in the EEA to guarantee judicial enforceability of the data protection level. Now, another example is the draft EU scheme for the Cybersecurity Certification of Cloud Services, or EUCS. It's been delayed for years over the discussion of whether it should include sovereignty requirements, which would in fact have nothing to do with cybersecurity. Fortunately, it seems like the idea has finally been given up now, but the discussion is likely to linger for years to come. But all of these admittedly quite relevant concerns about sovereignty must be weighed against the critical cybersecurity protections and data privacy protections that could be achieved with cloud computing and global networks. The fact is, sovereignty requirements for cloud services do not improve cybersecurity. They actually can have the opposite effect. Sovereignty requirements limit the ability to build global data sets of malicious cyber indicators, making it virtually impossible to develop and deploy security solutions that effectively leverage AI and machine learning to detect and mitigate cyber risk. Sovereignty requirements also make it more challenging to mitigate large volumetric cyber attacks, which are best addressed using large globally distributed networks. Such attacks are constantly getting bigger. Just recently, Cloudflare shared the news about another record-breaking campaign of hyper-volumetric L3 and L4 DDoS attacks, including the largest DDoS attack we've ever seen, 3.8 terabits per second. Now, EU policymakers and regulators in favor of sovereignty requirements for cloud services appear to have failed to consider how such requirements can impact the security features that are critical to keeping their networks and data protected from bad actors. Global knowledge is necessary to identify and stop attacks that could come from anywhere in the world. Enabling the use of AI and machine learning to identify and automatically mitigate malicious cyber behavior depends on having access to large global data sets. For example, the size of Cloudflare's global network puts us in a unique position to understand the evolution of global threats and anomalous behaviors. To empower our customers with preventative and responsive cybersecurity, we employ machine learning technologies to automatically transform that information into protections against attempted exploitation of vulnerabilities, DDoS attacks, and other malicious cyber threats. In contrast, a provider limited by sovereignty or localization requirements would not be able to gain the cyber insights from pooling malicious indicators coming from the EU with those available globally, which would leave customers in the EU with reduced access to threat information and automated mitigation of attacks, ultimately making them more vulnerable to cyber attack. Having a global network also allows cyber attacks to be blocked as close to their origins as possible. In contrast, mandating that a cybersecurity provider restrict operations to the EU means that all attack traffic must be imported to the EU. This approach loses the benefits of having a global network to mitigate attacks and has the potential to overwhelm EU networks that end up being required to carry attack traffic. Because sovereignty requirements are likely to have the effect of reducing access to cybersecurity mitigations and threat data, such requirements would risk misleading customers into using services that appear to be more secure based on their sovereign label, but actually provide less security from a technical perspective. And critically, this need for a global approach to cybersecurity benefits privacy too. The GDPR's application should be considered with the cybersecurity benefits of data processing in mind. Building on the GDPR's existing Recital 49, which rightly recognizes cybersecurity as a legitimate interest for processing, we believe personal data that needs to be processed outside the EU for cybersecurity purposes should be exempted from GDPR restrictions to international data transfers. Such a shift would be a truly pro-privacy application of the GDPR. The truth is, the better an organization is at detecting and thwarting security risks, the more protected its data is. And aren't we all tired of the headlines about data breaches? For us mere data subjects, the barrage of alerts about data breaches impacting our government identifiers, our sensitive healthcare data, or the compromise of our banking credentials, it's too much. It's breach fatigue. And as individual data subjects, in many cases, we're powerless to do anything to protect ourselves. So just as many of us have given up on trying to opt out of cookies because we get cookie notifications every time we try to do almost any single thing on the internet, we're starting to end up in a place where we might be thinking, what's the point of trying to keep any of my data private? It's just going to end up getting compromised in a data breach because the service provider I had to use didn't keep the data secure. But what if service providers could actually provide robust protections and data subjects could feel empowered by the fact that their data is processed by a provider, employing cutting edge security measures that adapt as threat actors change tactics? That'd be nice, right? Unfortunately, having that kind of security isn't scalable for every organization if the organizations are required to use sovereign solutions that can't adapt to changing threat vectors. So, given the pressures we're seeing from various players in Europe and the growing desire for digital data sovereignty, and with it, data localization, that's not likely to reverse course anytime soon. But I think it is important for all stakeholders to acknowledge that when we're talking about solutions that are designated to achieve data sovereignty, these solutions may not, and often will not, provide better data protection or better data security. So today, I've laid out how overly restrictive data localization can undermine cybersecurity efforts by reducing the effectiveness of protective measures and limiting access to crucial threat information. And I'm urging us to take a truly global perspective on data processing to effectively combat cyber threats. Using collective insights and privacy enhancing technologies can bolster defenses against evolving threats. We need to find ways to address the understandable desire for technological or data sovereignty without jeopardizing security or privacy protection, and also be clear about the necessary trade offs involved. Only with this added level of transparency will users be able to make fully informed, sovereign technology choices. It's going to be difficult, but as is true with many things about the internet, rules and regulations are not likely to be the best or only answer. Instead, we need to invest in privacy enhancing technologies and security measures that protect data regardless of its location. These technologies can help secure personal data, giving individuals greater control and confidence, and enabling them to use the most innovative services the internet has to offer, while at the same time protecting them from personal data breaches. Only by implementing these kinds of technologies can we have true digital sovereignty, the ability for individuals to securely use digital services of their choice and to control their data as they move around the global internet. Thank you so much for joining me today, and enjoy the rest of your Bitkom sessions.